Chris Finlayson.
I'm really pleased to take a call on this bill because it is actually a practically important bill. Let me say immediately, we're not talking about anything to do with public international law, the sorts of disputes that often occur between states as to boundaries and so on, and that need to be determined in the International Court of Justice. No, we're talking about private international law, or what was often called, when Mr. O'Rourke and I were at university, the conflict of laws. What happens when legal systems collide? So a couple may have been married in England, they come back to New Zealand and they seek to divorce, or that may got married in Saudi Arabia, they come back and seek a divorce in New Zealand. Is it possible to seek a divorce in New Zealand? What's the law that would govern the determination of that particular relationship? And so they are the sorts of issues that arise in the conflict of laws, custody disputes, where children are taken out of the jurisdiction. Family disputes are very common in the conflict of laws. I recall when I first studied the subject, there were about 8 students in the class that because now of growing interactions between states, the frequency of these sorts of problems, more and more students are studying this area, and it's very important. This is a hugely significant and practical question, therefore. It's not some airy-fairy academic subject, and as Mr. Bennett said in his excellent speech, it's something that has engaged a number of foreign jurisdictions, including Canada and more recently Australia. Basically, when there is a clash between legal systems, if there is litigation with a foreign component, 2 questions arise. The first question is, where should the case be litigated? And so take my example of a cause of action may have arisen partly in New Zealand and partly in Saudi Arabia. The issue would be, well, should the case be determined in Saudi Arabia or should it be heard in New Zealand? If it's heard in New Zealand, the New Zealand party will be very much happier than if it's heard in Saudi Arabia, because the New Zealand party will understand the court system and the way in which you go about preparing a case in New Zealand and those sorts of matters. So that's called, what's the forum conveniens to determine the dispute? The second issue which arises is, what's the law to be applied in those circumstances? Take my hypothetical, is it going to be the law of Saudi Arabia or the law of New Zealand? If it's litigated in New Zealand, but the law is that of Saudi Arabia, then it gets rather complex, because the person who seeks to rely on Saudi Arabian law has to prove Saudi Arabian law as a fact. And so you can see there are all sorts of complexities that begin to creep into the litigation, and often this area of the law suffers from what could be called satellite litigation, where instead of getting on with the substance of the dispute, people are spending all their time in court determining these sorts of matters. So the first question, as I said, is, where should the case be heard? The second question that often arises is, what is the law to be applied? In the law of contract, it's normally spelt out in the contract, so it's no big deal. Normally the contract will say, all matters arising for dispute shall be governed by New Zealand law or English law. It becomes much harder when one is dealing with the law of tort, and as Mr. Bennett said, there are various types of torts. There's negligence and defamation. Negligence and defamation would be the most common ones, I guess. But then you get into this difficult question of, what is the law that governs the particular resolution of the allegation of negligence? And that's where we get to this legislation. And Mr. Bennett has rightly pointed to a number of old cases, the most famous one being Phillips and Eyre, where the double actionability rule was propounded, if you like, and it's been most recently applied in New Zealand in a case called Baxter and RMC Group. So the purpose of this bill is to simplify the law, abolish the double actionability rule, and introduce new rules as Mr Bennett has spelled out in his speech. So it's a very interesting area of the law. I'm pleased the Labour Party is supporting it. It is, as Chapman Tripp said, a no-frills piece of legislation. Some members' bills seek to change the world. This doesn't do anything other than clarify an important area of the law. It's a brilliant effort on the part of Mr Bennett, and I commend him for his hard work.